amongst us, we have Mr. B G Harindranath, the advocate of Punjab High Court of Kerala. I'm sorry, because Punjab and Haryana High Court is so on your mind that one feels that the speaker is from that place. Law Secretary of Government of Kerala and a retired district and session judge. Besides that, he was a resource person, not only in Kerala Judicial Academy and NJ, and he's still continuing to perform his duties. So his passion to share his knowledge is taken from the fact that even after demitting the office, he continues to discharge his knowledge sharing. And the previous webinar, which he did with us, is already doing so well because the simpliciter manner in which he explains is deep roots in the mind. Today's topic, just we were talking that he takes his sessions in a manner that it is understood by everyone. So we thought, why not take the contours of some topic, contours of executive and legislative powers of states under the Constitution of India. Is an important facet. Those who have been understanding and reading the Constitution of India. On this topic, I will ask Mr. Harinderanath to share his insights over that. Over to you.
Thank you, Mr. Vikas. Thank you, everyone. Very good evening to all of you. I think we'll start the session today. It is actually a difficult topic. In fact, any topic on the Constitution, unless you have some practical experience in the matter, either as arguing as a counsel or dealing with the various provisions on the practical side, it is slightly difficult to understand the real scope and meaning of the provisions of the Constitution. But let me tell you, God has been little kind to me, because I had the opportunity, though I start as a district judge, you don't get much opportunity to deal with the provisions of the Constitution. But as a law secretary to the government of Kerala for a long period of 5 years, I had the opportunity to draft many legislations. I had to sit in the assembly, watch the legislation taking place, the votings, everything happening in the legislature. Then I had to write opinions. I had also to get documents where, and also letters which were sent by the central government and the state government. That way, I had a rare opportunity as a law secretary to the government of Kerala. And as you know, in Kerala, every now and then all these problems crop up with all sorts of allegations and other things, which puts the government in a quandary. So there also the law secretary's role is very crucial. And you see, law secretary is almost in all committees chaired by the chief secretary or any other committee chaired by the ministers. We are a feature there because they always some legal matter crops up and you will have to assist the executive as well as the political executive and the administrative officers. Now, as the law secretary, as I told you, I had the opportunity. The first thing we look at when a legislative measure is being taken by one of the administrative departments is whether we have legislative competence or not. Then we examine whether if we have legislative competence, whether there are other legislations on the point by the state or by the central. And if you find that there is a legislation by the central parliament, the question of repugnancy may arise. You look at Article 254 of the Constitution. If it is an ordinance, obviously you look at 213 of the Constitution. And in the case of ordinance, you will have to get the prior assent of the president, whereas in the case of 254-2, after the legislature passes the bill, it will have to be sent to the president for assent. So the 213, it is called prior instructions from the President of India. Now, so far as administrative duties are concerned, you all know that it is coextensive with the legislative power. Either of the parliament, if the parliament has legislative power, the administrative power is coextensive with the parliament's legislative power. Similarly, in the case of the state also, it is coextensive with the legislative power of the state legislature. Now, before I go into all these things, we have to understand the structure of the state government, because everybody knows the state government starts with the governor. The governor of the state is the head of the state, and all executive powers are vested in him. But this is a misnomer. In fact, I wouldn't call it a misnomer, but you see, though all executive acts are taken in his name, he is bound by the advice of the Council of Ministers. In fact, in Maruram's case, celebrated, or one of the most celebrated judges from Kerala, that is Justice V.R. Krishna Iyer. In fact, incidentally, I and Krishna Iyer's ancestral villages, and I belong to the same village, that is Koilandi. His father was one of the stalwart lawyers in Koilandi. Later, he went to Tellicherry District Court to practice. And Krishna Iyer, in fact, practiced initially in the Tellicherry District Court and then came to the Kerala High Court, where he became one of the leaders of the bar. So, now let me take you to chapter 2 straight away, because it's a vast topic. So I want to slightly rush through the matter. See, it is chapter 2 which deals with the executive power of the state. And Article 153 says that there shall be a governor for each state. And then the all executive powers, the 154 says that shall be vested in the governor. The entire executive power of this state shall be vested in the governor and shall be exercised in either directly or through the officers subordinate to him in accordance with the Constitution. That is what Article 154 says. Now, we have to understand, even though in the American Constitution, the executive is very powerful because they don't have a council of ministers or anybody to advise them. They act on their own. And there is a complete separation of powers so far as the American Constitution is concerned, because it is all the three organs of the state, legislature, executive, and legislature, executive, and the legislature and executive and judiciary are completely in separate silos. Now you see, so far as our constitution is concerned, whether it be the central government or the state government, there is under Article 163 of the Constitution a council of ministers headed by the chief minister to aid and advise the governor. And judicial decisions and other, in Maruram's case, Justice Krishna Iyer has held that in the matter of granting pardon under Article 162 of the Constitution of India, the advice of the Council of Ministers would be binding on the governor, whether he likes it or not. The word used by Justice Krishna Iyer is very crucial in this, whether he likes it or not. So the governor is absolutely bound by the advice of the Council of Ministers, except in matters where Constitution has given separate power, independent powers. That is where whether a particular Council of Ministers do enjoy the support of the majority support in the legislature, whom to call, because who is really having the the support to the maximum number of members of the legislature. These are matters, and there are some independent matters which he has to look into. But so far as other executive matters are concerned, being a cabinet form of government, like England, the Council of Ministers aids and advises the governor, and the governor is bound by their advice. And in the words of Justice V.R. Krishna Iyer, one of our best judges, he is bound whether he likes it or not. So we have to understand our constitution, because people, actually governor is imposed by the central government in various states. It is one way of controlling the state government and then reporting to the central government back. And there, he does not actually, in reality, though he is appointed by the political executive who have been elected by the people of India, nonetheless, he does not have the popular will of the people of the particular state in which he is posted. Ordinarily, the governor will be from another state. No person is ordinarily appointed as a governor in his own state. So therefore, the popular will or the people's mandate is always with the Council of Ministers who are part of the legislature. That is why I said there is no complete compartmentalization. as envisaged in the American Constitution, in the Indian Constitution. So far as American Constitution is concerned, governors of the state are directly elected. Similarly, the President of the United States and Vice President are directly elected. Our case, even the Chief Minister is not directly elected. MLAs are elected. MLAs themselves elect one Chief Minister, and the leader of the majority party, and the governor invites them. So this is we have actually accepted an assimilated version of American Constitution, Canadian Constitution, Australian Constitution, and the English Constitution. And basically, most of the legislative relations are just as it is provided in the Government of India Act of 1935. When Britain proposed to give some kind of home rule to the native Indians, they had enacted this 1935 Government of India Act. And under the Government of India Act, we had a lot of legislatures. We had our own chief ministers in various provinces under the central government. And most of the provisions relating to executive power and administrative legislative relations, these are all taken from the Government of India Act, especially relating to finances and other matters. You will find a comparison. You will find that there is a verbatim reproduction of certain clauses in the Government of India Act, though it was thoroughly debated in the Constituent Assembly. Now, you see, 163 of the Constitution says, Article 163 says that there shall be a Council of Ministers, and judicial decisions also say that governor is bound by the aid and advice of the ministers. Now, governor's powers are varied. One is governor's power of granting pardon under 161. In this case also, the governor's power is circumscribed by the advice of the Council of Ministers. If the Council of Ministers says you shall not grant pardon or you shall grant pardon in a particular case, governor's hands are fettered. That is what Maruram's case says and several other cases say. Even Sriharan Murugan, latest decision in 2016 relating to the Rajiv Gandhi assassination case, they have again reiterated these principles of law laid down in Maruram's case and earlier decisions also. Now, this is so far as governor's powers are concerned. Now, what is the extent of the administrative powers of the state government? See, administrative power of the state government is coextensive with that of the legislative power. Even Parliament's power, it is coextensive with that of the Parliament's power to legislate. This is provided under Article 162. I shall come to this aspect later. See, Article 162 reads, subject to the provisions of the Constitution, the executive power of the state shall extend to the matters with respect to which legislature of the state has power to make laws. So, if a legislature of the state does not have power to make laws, ordinarily, the executive power of the state will not extend, except you will find in certain legislations passed by the Parliament, by rulemaking authorities, or in the statute itself, power to administrative powers will be conferred on the state government or state executive. Except, so ordinarily, if such extension is not there, if the legislative power is solely vested in the Parliament, unless the Parliament clothes the state government with the power to administrative power to administer that particular law, the state government does not have power. Administrative power, therefore, is always coextensive with that of the legislative power. Now, we will also have to examine the legislative power of the state under the Constitution. Now, so there is a proviso to Article 162, which we will have to read carefully. Provided that in any matter with respect to which legislature of a state and Parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by the Parliament upon the Union or the authorities thereof. Now, the executive power of the state is limited by what is expressly conferred by the Constitution and also the laws made by the Parliament. This we will have to remember when we are dealing with the executive power of the state, because these things, come before the state governments many a times. And people have grand notions of federal polity in India. The distinction between American Constitution and the Indian Constitution is the residual power always in the American Constitution rests with the states. Whereas, so far as our country is concerned, the residual powers that I'll come to later, residual powers of legislative and administrative residual powers vest in the union government and the parliament, union parliament, so union legislature. So we have to understand that though there is a federal polity in India, it is not evenly balanced under the constitution. There may be so many debates about it, but we have a strong center. Of course, we always say strong states. Obviously, I am not making an emphasis on strong state, but I emphasize that under our constitution, center is pretty strong enough as per the provisions of the constitution, which I'll take one by one. We shall go through that. Now, so far as first we will go to the how the executive power is exercised. It is under Article 166 of the Constitution of India. See, all executive power shall be expressed to be taken in the name of the governor, which, so you will find all by the order of the governor signed in all legislations which has been passed by the Kerala Assembly. Towards the footer that there will be a word. This is my experience, I am telling you. By the order of the governor. Then last I will sign law secretary. Because I am acting as directed by the governor. Governor has given his assent, and therefore governor's name will be there. It will be by the order of the governor. Even in ordinances, it is like that. So all executive powers, all executive powers are in the name of the governor. Now, if you grant pardon, it will be by the order of the governor. If you see some government order coming, it will also be by the order of the governor. And underneath, the secretary to the department concerned would have put his signature and initials and name will be there. So you understand that it is as per the provisions contained in Article 166 of the Constitution. All executive actions are expressed to be taken in the name of the governor. So we have Kerala governor. When I was the law secretary to the government of Kerala for all 5 years, the governor of Kerala was former Chief Justice, Justice P. Sadashivam. I had a great relationship with him. I had the occasion to learn a lot of things from him. There has been an occasion where he refused to sign a legislation and send it back to the legislature. And of course, the Supreme Court, in fact, the ordinance part of it, which is the Supreme Court struck down the ordinance on certain grounds, which obviously I will not be discussing what it is, but Justice Sadashivam's views were correct in that matter. But see, once it is returned to the legislature, second time the legislature passes and sends it to the governor. Governor has no other go but to sign it. So this is the normal procedure which happens, but it rarely happens because we have a law department. All law departments in India, almost all states, I think, except for Tamil Nadu. I think in Tamil Nadu also, when I was a law secretary, my counterpart in Tamil Nadu was a district judge. We always, High Court posts one of its senior-most officers as the law secretary in all states. So several places it is called principal secretary to the law states. It is called law secretary and legal remembrance. Whatever be the nomenclature, it invariably is the district judge concerned of that particular state. Now, for this expression expressed to be taken in the name of the governor, you find under Article 299 of the Constitution, 299(1) of the Constitution of India, every contract entered into by the government with any person shall be expressed to be made in the name of the governor. So suppose otherwise it will be void. Shall, the word used is shall. So if the government department enters into a contract with a third party under Article 299(1) of the Constitution of India, similarly as provided in Article 166, it has to be expressed in the name of the governor. So I shall just take you to Article 299(1). 299(1) says all contracts made in the exercise of the executive power of the union or state shall be expressed to be made by the president or by the governor of the state, as the case may be. And all such contracts and assurances of property made in the exercise of that power shall be exercised on behalf of the president or the governor by such persons and in such manner as he may direct and authorize. That is what the Constitution provides. Now, let us come back to Article 166. Now, if you see all powers, I have already stated that governor has to exercise the powers. Governor can only exercise the powers in accordance with the aid and advice given by the Council of Ministers. Now, the third part of it is, see, if you have to do something, let us say buy a land or acquire some land for the government, then see, Council of Ministers may have to hold a meeting and then pass a resolution and then advise the governor. It will be a cumbersome effort. It will not move forward. For everything you have to rush through this mechanism, Council of Ministers. It is not possible. So Constitution itself is founded via media. There, Article 166(3) of the Constitution provides the methodology. See, governor shall make rules for the more convenient transaction of the business of the government of the state and for allocation among ministers of the said business insofar as it is not business with respect to which the governor is by or under the Constitution required to act in his discretion. So there are some discretionary powers given to the governor. Rest of all matters, he can frame rules. And as per the rules, which are called the rules of business of the government, every state government has got the rules of business of the government. These rules of business of the government are framed under Article 166(3) of the Constitution of India. And the rules of business are allocated among ministers, various ministers. You have the Council of Ministers, Chief Minister as his head. Then portfolios are there. For instance, agriculture, finance, law, home affairs. Then there is water resources, then there is labor. All these matters. These are separate departments, and it is allocated among various Council of Ministers. So therefore, you find Minister for Agriculture, Minister of Human Resources, Minister for Law, Minister for so and so and so and so. This is as per 166(3) of the Constitution, in accordance with the rules framed by the governor of the state. The business can be allocated. So therefore, even though it is made in the name of the governor, as suppose the rule confers power on the minister can act. Therefore, it is deemed to be the act of the governor himself. Now, let us assume a situation where particular government department wants to pass a legislation pertaining to police in the state. So it will be with the Home Department. So there will be the administrative department, Home Department in the state. And the administrative department's head, that is the minister, because Constitution, whenever the word executive is used, we have to understand that it is administrative executive. It is not the IAS officers and others. Political executive. Though in a speech, Vallabhbhai Patel, while he was speaking to the IAS officers, he had described them as administrative executive. There is in the Constitution no concept of administrative executive. Executive means political executive, ministers, because 166(3) is very clear, which says for allocation among ministers, not allocation among secretaries to the government. So secretaries to the government are appointed under Article 309 as per a statute framed by the state, union government or the state government under Article 309. Therefore, they are not even, though it is as per a law made by the union government, parliament or the state legislature, they are actually not directly appointed as contemplated under the Constitution. Tomorrow, if the government of the day feels that we don't want particular service, all India service, we will change it in some other methodology. The government of the day can bring the bill in the legislature and pass such a law. Then therefore there will be abolition, new kind of cadre will come. Because these IAS cadre, all India services are molded in the fashion of the ICS in England, English, they had this Indian civil service, like we have Indian administrative service. It can always be changed. Now look at the case of a district judge. Can by legislature pass a law in that regard and appoint district judges in any other manner under Part 6 of the Constitution? No, can't do it. Because there is no provision for making laws. And in Bal Mukund Shah's case, they have held that the state legislature cannot pass a law because it is a complete code in itself. So that is why in All India Judges Association case, the Supreme Court had held that even district judges are essentially constitutional functionaries. Even all administrative officers under the state are all constitutional functionaries. Nonetheless, they are appointed by a statute, and the statute can be changed. Whereas the judicial posts, nothing can be done by the executive or the legislature, because we are the judiciary is completely insulated under the Constitution from executive interference. I'm not going into those matters, but I'm only telling you, under Article 166(3), the governor shall make rules and allocate the business among Council of Ministers. Now, we have the rules of business. As I told you, if a police act has to be changed, some powers from the police have to be taken away, conferred on some other authority. So the administrative executive takes a policy decision, which means that the political executive, namely the minister handling the home portfolio, will take a decision and then send it and prepare a note and then send it. And then because rules of business in the matter of legislation says that it has to be passed by the Council of Ministers. So when I was a law secretary, the procedure as per the law, the rules of business framed by the governor is the administrative department, whichever department, the home, agriculture, new agricultural law should come, new land reforms law should come, then the revenue department, they will send the policy decision with their suggestions and a skeleton draft of the proposed legislation. Then it is the duty of the law department to vet that, give it a technical shape. This is provided in the rules of business itself. So what the law department does is, what we used to do is we immediately take up the legislation. I'm coming to the legislation because from the practical point I'm saying, so it will be easier to understand. Now, when the legislation comes to the law department, the law department's employees are all law graduates, most of them. They have been part of the legislative process for many years, and they have acquired a lot of knowledge in these matters. They have acquired a lot of knowledge in these matters. So what we do is, there is a Rule 45 in the business rules in Kerala. There will be a corresponding rule in every other state's business rules. So we examine the content of the legislature and we examine whether there is under which list it comes under the Constitution, 7th schedule. You know, the Constitution of India has something called the 7th schedule. And under Article 246 of the Constitution of India, that is Chapter 1 that defines the legislative relations. So we have the Constitution of India, there is a 7th schedule. There are 3 lists in the 7th schedule. The first list, containing 97 items, is the central list, in which only the Parliament, the subjects which are enumerated in the first list, only the Parliament exclusively can make laws. Then there is a second list, which is a state list. Power is conferred on the state legislature to enact laws regarding the subjects enumerated in the second list. Then there is a third list in the 7th schedule, which is the concurrent list. There, the state legislature as well as the Parliament can enact laws. Now, here is a complication comes, which I shall take you to these complications. Now, under the legislative relations between the union and the states is dealt with under chapter 1 of part 11 of the Constitution. Chapter 2 deals with the administrative relations. Now, subject, it says, Article 245 says, subject to the provisions of the Constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of the state may make laws for the whole or any part of the state. Now, state legislature can only make legislation with regard to the state. Parliament, obviously, entire country it can make. Then 246, next time, 246. Notwithstanding anything contained in clauses 2 and 3, Parliament has the executive power to make laws with respect to any of the matters enumerated in List 1 of the 7th schedule. Now, there is a List 1 of the 7th schedule. Only the Parliament has got the power to make laws. Then, notwithstanding anything in clause 3, Parliament and subject to clause 1, legislature of the state also shall have power to make laws with respect to any of the matters enumerated in list 3. This is the concurrent list. So in Article 246.2 says concurrent list subject to the provisions contained in list 1, state as well as Parliament can make laws. Third is regarding the subjects enumerated in list 2, where the state alone has the power to make laws. Now what we do is, we actually take up the subject which is given to us by the administrative department as the law secretary. We examine, law department examines it thoroughly, whether there are any, which list it comes. We find out the entry, subject entry, whether it comes under list 1, 2 or 3. If you find that it is coming under list 2, much of the difficulty will, there is not much difficulty, you can straight away. But if it comes under list 1, the state legislature is denuded of power to legislate. Now, there was one, when I became the law secretary, there was this traditional medicines and other physicians in Kerala. They felt that the Patents Act is making inroads into their profession. And the state government wanted to legislate. I mean, bring in provisos to Patents Act. A similar enactment they wanted to bring. So a committee was constituted. The committee debated about this. They came up with a report. But then when we examined it in the law department, patents comes within the exclusive domain of the Union of India, Union Parliament, because it comes under list 1. State legislature has no power to legislate on patents. So the matter was immediately dropped. We did not go any further. This is why I tell you, on the practical point of view, this is how legislations take place in the state as well as in the center. Now, if it is within the list, if it comes within list 3, there is a difficulty. We examine whether there is central legislation on the point. Now, suppose there is a central legislation on the point. The state is not fettered from passing any law. State then, under Article 254(2) of the Constitution of India, if there is a repugnancy between the proposed state legislation and the central legislation which is in existence, we have to, under 254(2), the state legislature has to send the bill to the president for his assent. Now, this is what 254(2) says. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by the Parliament or an existing law with respect to that matter, then the law so made by the legislature of the state shall, if it has been reserved for the consideration of the president and has received his assent, prevail in that state. Now, if the state government sends it for the assent of the president, and the president gives assent, then notwithstanding the fact that there is repugnancy between the state legislature law passed by the state and the law passed by the center, the law passed by the state will prevail over the central. Now, suppose if there is under Article 254(1) of the Constitution of India, if no assent is obtained, the state law will be void to the extent of repugnancy. It is as though there is no law. There is no law. There was in fact, when I practiced in the High Court, there was this conflict between the 1897 Land Acquisition Act, and Kerala government had passed a Land Acquisition Act in 1961. And the division bench of the Kerala High Court held that assent of the president was not received for the Kerala Act of 1961. And therefore, it was repugnant to the 1984 amended provisions of the Land Acquisition Act. And therefore, the state law, to the extent of repugnancy, was held to be void. Now, the second question is, we have the CPC, Civil Procedure Code. We had Order 34. You all know what Order 34 deals with. Order 34 deals with mortgages. In Kerala, during the 60s, I just don't remember the date. During the 60s, the CPC was amended. The Civil Procedure Code was amended, and separate provisions were provided for the decision in the mortgage suit, especially in the matter of passing preliminary decree and final decree. In the matter of a simple mortgage, the Kerala CPC did not contemplate the passing of two decrees. That is, one is the preliminary decree and final decree. But when it came to the the CPC was then amended on two different occasions. In 1908, CP was amended in 1976. Then the CPC was later amended in 2002. Now, on both these occasions, the first time when it was amended in 1976, when the matter came before the division into the Kerala High Court held that because the later law had abrogated the under Article 254 of the Constitution, because there was question of repugnancy between State Order 34 and the Central Order 34. Central Order 34 will prevail. Then in 1990, Kerala again amended the CPC, went back to the old position. Then 2002 amendment came to the CPC. Again, the Kerala amendment goes because it is repugnant to the later law of the Supreme Court. Now, that is why there are several such situations where the repugnancy may arise. Now, legislative relations, once more we will have to go. We have a feeling now, after cursory examination of the provisions of the Constitution, that the Parliament has no power to legislate under in respect of matters enumerated in the list 2 of the 7th schedule, which is called the state list. No, it is not so. Parliament has, in certain circumstances, it can. Now, I shall take you to residuary powers of legislation, 248. Subject to Article 246A, that is the latest amendment to GST matters, Parliament has the exclusive power to make any law with respect to any matter not enumerated in the concurrent list or the state list. That is because under the entry 97 is any other matter. It is left to the central. Now, we'll take 249. This is where the Parliament's overriding powers are enumerated in Chapter 1, even though there is a state list. Now, let us look at notwithstanding any 249(1). Notwithstanding anything contained in the foregoing provisions of this chapter, if the Council of the States is declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary and expedient in national interest that Parliament should make laws with respect to any matter enumerated in the state list specified in the legislation, it shall be lawful for the Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. Bracket, they have added goods and services, that is new amendment. Therefore, if the Rajya Sabha with 2/3 majority passes a resolution and the resolution is in force and Parliament then is clothed with the power to legislate in respect of matters which are exclusively mentioned in the state list. Now, this is where the parliament's power, overriding power, one aspect of parliament's overriding power comes. But the subsection subarticle 2 says a resolution passed under clause 1 shall remain in force for such period not exceeding 1 year, as may be specified there. So the maximum period which it remains in force will be 1 year. Then the law made by Article 294.3 says law made by the Parliament which Parliament would not, but for the passing a resolution under, have been competent to make, to the extent of incompetency, cease to have effect on the expiration of period of 6 months after the resolution has ceased to be in force, except as respect to the things done or omitted to be done before the expiration of the said period. Now, this is what article, this is not an absolute power, but nonetheless, I'm just pointing out that in certain exigencies, Parliament has the power. Now, 250, when there is a proclamation of emergency in operation, there can be a financial emergency under Article 360. Now, let us examine a situation where the state government is in tortoise, finances are in tortoise. Then the central will step in under Article 360 of the Constitution of India. Then they can declare a financial emergency. Then you see, Article 250 says, notwithstanding anything in this chapter, Parliament shall, while a proclamation of emergency is in operation, have the power to make laws of the whole or any part of the territory of India with respect to goods and services, tax provided in Article 2, or any other matters enumerated in the state list. So whatever be the matter enumerated in the state list, if a declaration of emergency is made, if it is a internal problem is there, the declaration of emergency is there, center has the power to make laws. So it is this federal structure is very much giving great powers to the Parliament, central. Maybe our constitution's framers felt that if the nation has to remain as one, the viviparous tendencies had to be curtailed. It had to be, the center had to be given this power. During Jawaharlal Nehru's times, there were such legislations. You remember the internal emergency in 1975, ADM Jabalpur case and so many other things. See, so the center has got the power. If an emergency is proclaimed, even the matters in state list, it can pass laws. Now, nowadays, it is a money market because after we became a full-fledged market economy, many other state governments, finances are, if they are not properly managed, center will have to step in under Article 360 of the Constitution of India. And then they are even budget, financial bill, everything can be passed by the Parliament. Now, a law made by the Parliament, which the Parliament would not, but for the issue of proclamation of emergency, have been competent to make, shall to the extent of competency cease to have effect on the expiration of 6 months after the proclamation ceased to operate. Except, so this is not an absolute power. If the proclamation of emergency is taken off, and after the expiration of 6 months, it goes off, except with regard to things done under the legislations. So these are the matters. Then we come to Article 251. So under Article, I'm not reading because there is a paucity of time. Under Article 251, the Parliament may not have power to make laws, but if two or more states make a request with regard to the matters enumerated in the state list, Parliament can still under Article 251 pass a legislation. That is that says nothing in Articles 249 and 250 shall restrict the power of legislature to make laws. And then if the provision of that is there, then that is under 252. It is under 252 that power of the legislature of 2 or more states by consent to, and adoption of the state legislature by another state. Now international agreements are there. When India enters into an international agreement, unilateral laws are there, Arbitration Conciliation Act and all. See, to give effect to that, even if some matter comes within the concurrent list the state list, Parliament has the power under Article 253 to enact laws. to give effect to international agreements. Now, the other matter I have read, 254. Now, we have understood the basic gamut of the Constitution. Now, repugnancy, the Supreme Court has in various decisions held. See, it is not necessary that there should be complete repugnancy as contemplated ordinary parlance. Now, I shall take you all to 2 or 3 decisions of the Supreme Court. One is Hingir Rampur Coal Company versus State of Orissa. You may note down AR 61 Supreme Court 459. The other is State of Orissa versus M.A. Tullock and Company. AR 1964 Supreme Court 1284. Then Bajinath Kedia versus State of Kerala 1969 3 SEC 839. Now, there were, see, I'm specifically talking about the Mines and Minerals Act, Central, and the Kerala Acts, which permits the state to make inroads under entry 18 under the heading land reforms and land and other matters. Now I shall just read to you. The state has a power under entry 23 of list 2. That is a state list. And entry 32, I just read the decision so that it will be easier for us. This is what has been held in Hingipur Ramkur Coal Company. What entry 23 provides is that the legislative competence of the state legislature is subject to the provisions of list 1 with respect to regulation and development under the control of the union. And entry 54 in list 1 requires a declaration by the parliament by law that the regulation and development of mines should be under the control of the union in public interest. Therefore, their lordships say, if a central act has been passed for the purpose of providing for the conservation and development of minerals, and if it contains a requisite declaration, that is, it is for the development of minerals, then it would not be competent to the state legislature to pass an act in respect of the subject matter covered by such legislation. In order that the declaration should be effective, it is not necessary that the rules should be enforced. All that is required is a declaration by the parliament. That is, it is expedient in the interest of public interest to take the regulation and development of mines under the control of the union. In such a case, the test must be whether the legislative declaration covers the field or not. Judged by this test, there can be no doubt that the field covered by the impugned act, that is the Mines and Minerals Act, is covered by the Central Act of 53 of 8. Then their lordships, Bajinath Kedia, and they say that when there is a declaration by the parliament covering a particular field in respect of an enactment, either under entry 54 of list 1 or entry 23, the state will be denuded, notwithstanding the fact that there is no, what you do is not to read the 2 enactments and see whether there is repugnancy or not. The repugnancy arises when there is a legislation completely covering the field. Then the repugnancy arises. Not only with respect to matters enumerated in list 2 and list 3, vis-a-vis list 3, but the matters enumerated in list 2 state list vis-a-vis the central legislature, if it is made subject to the law made by the central legislature and there is a declaration of that kind, the state legislature would be denuded of its power to make legislation. Now, so far as mines and minerals, I don't want to take you further in this, but all we have to understand is there is a later decision by Justice Chandrachud, which says that if 2 central legislation and the state legislation occupy the same field, you don't have to examine one by one the repugnancy of each provision. The state legislation would be void to the extent in the light of the central legislation occupying the entire field. So this is what we have to understand. Therefore, so much so regarding the legislative relations. Now let us come to the administrative relations. There also the center's vast powers we find in chapter 2 are the same. This is legislative part 11. One deals with legislative relations. Chapter 2 deals with the administrative relations. Now 256 says the executive power, Article 256 says that the executive power of every state shall be so exercised as to ensure compliance with the laws made by the parliament and any existing laws which apply to in that state, and that the executive power of the union shall extend to the giving of such direction to the state as may appear to the government of India to be necessary for that purpose. Now look at this. The union government is clothed with the power to give direction to the state government with regard to the exercise of powers by the state with regard to the laws made by the parliament. This is a real inroad. And how to administer that? The central government can and is empowered to issue necessary instructions. Then 257 says the executive power of every state shall be so exercised not to impede or prejudice the exercise of executive power of the union. States can exercise their powers, but it shall not impede or prejudice the exercise of executive power of the union. And the executive power of the union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. So the government of India feels that something is necessary for a particular purpose with regard to implementation of with regard to the exercise of executive power. The state shall exercise their executive power so as not to impede or prejudice the executive power by union. Now let us examine a case where it is Kerala police, let us say any state police, Tamil Nadu police conducts an investigation into a particular matter. And the investigation is rightfully taken over by the Delhi, investigation is under the Delhi Police Establishment Act by the CBI. Maybe a matter coming within the domain of the CBI, and then there will be some other offences also. For instance, Human Organs Transplantation Act. There is an act like that, where all investigations are to be done by the Delhi Police Establishment. And if there is an IPC offence, even then, Supreme Court has held that only the CBI has, in same transaction, if there is an IPC offence, the Supreme Court has held that only the CBI can conduct investigation. In that matter, state government cannot impede or prejudice the exercise of executive power of the union. This is what Article 257 says. The 257.2 says that it shall also extend to giving directions to the state as to how administrative power should be exercised. Now, this is how. Now, I am not taking you to the entire dispute relating to waters is there, then interstate. These are all a lot of. It will take a lot of time for me to continue. We have already completed about 1 hour. Now, I'll just take you to one situation where, see, under the CRPC, this also sometimes crops up. There is a power to grant pardon. There is the power to commute the sentence. There is the power to power of remission under 432. In some of these cases, it has been held that the union government's power is overriding, and the power of the state government is subservient to that. So I shall take one is the suspension, remission, and commutation of sentences under 432 of the Constitution. So let us take a decision. You see, under Article 73 of the Constitution of India, executive power of the Union shall extend to the matters with respect to which Parliament is power to make laws, and Article 246 specifies that the matters with respect to which Parliament is power to make laws. Then, executive power of the Union, as I told you, shall be coextensive. It will extend over the whole territory of India. And then when there is conflict between these two powers, the commentaries say that the central power will override the state's power. Now, the section 434 is also very relevant in this matter. Section 434 of the Constitution of India. I'm sorry, 434 of the Criminal Procedure Code. The powers conferred under section 432 and 433 upon the state government may, in the cases of death sentence, shall be exercised by the central government as well. Then, as a rule, the Supreme Court in KP Mohammed's case was the state of Kerala, 1984 SCC supplementary 684 has held that as a self-imposed discipline, mercy petition would be decided by the President of India within 3 months from the date of prosecution. Now, 435 says, state government to act after consultation with this central government in certain cases. This says, the powers conferred under 432 and 433 upon the state government to remit or commute a sentence, where the sentence is for an offence which was investigated by the Delhi Police Establishment constituted under the Delhi Police Establishment Act of 1946, that is CBI or any other central investigating agency, or which involved the misappropriation or destruction or damage to any property of the central government, or which was committed by a person in the service of the Union or states, shall not be exercised by the state government except after consultation with the central government. Now, if the trial takes place within the state, it can, but then state government can exercise the power under 432 and 433. But then the 435 says that nonetheless, the power shall be exercised when it is CBI is investigating, or when central government's property is destructed, or when a central government servant commits a crime. The power of commutation or suspension or remission of a sentence can only be done after consultation with the central government in these cases. Now this is also the Law Commission of India. You find the Joint Select Committee had recommended this section 435 and it was enacted because there were a lot of conflicts in these matters. Now this is so far as the executive power of the union in the state and the legislative power of the union in the state. Broadly, I have said, but because we have almost, I think I've spoken for more than 1 hour. Thank you for patiently listening. And do I have to add anything, Mr. Vikas?
In a digital world, even the advocates can be controlled by someone. Asking the admin to unmute me. There's only one question, not also on the YouTube. It says, is there any way to refer the inquiries, tribunal verdicts under the present CRPC or administrative tribunals to review or rationalize the earlier British laws in independent India and to bring in the latest tune?
That is up to the parliament or people's representative to decide. They have the power to legislate. We have, of course, in the states, all these hackneyed laws. Most of them are being repealed. In fact, Parliament recently has done, after the Law Commission recommendation, they have repealed so many obsolete laws. And then there is also the courts can also declare there is a doctrine of disuse. Kerala High Court has in one case declared that because the doctrine of disuse, we have got this Hackneyed Carriages Act and all that. Not into really application, no real application for that. So many enactments like that have been repealed by the parliament and state legislatures. In fact, in Kerala, we had a commission headed by Justice V.R. Krishnaiyer. He had recommended repeal of lot of enactments. He used to do it pro bono. He never used to take money from the state government. And during my tenure as law secretary, we used to we have repealed a lot of laws in this region.
In fact, the central government has also repealed and are in the process of repealing, which have actually become obsolete, or you may say that they are of no relevance except for the statute books. And that's a right in a positive manner. And thank you, Mr. Harinderanath. It was as usual, an engaging session. And tomorrow, friends, we will be having a session on discovery and inspection, practical aspects with law. That is by Mr. S.R. Somashekar. We all know that his sessions are always being well received. So do stay connected with us at 6 p.m. And thank you, Mr. Harinderanath. You'll stay connected on and off the screen. Thank you. Namaskar.